All right, let's talk about two words you hear constantly in law school, and frankly, just in life: rights and duties. But what do they actually mean in the eyes of the law? Well, in this explainer, we're going to unpack these fundamental legal concepts, piece by piece, to make them crystal clear. Let's get right into it.
Okay, so here's the question that's going to guide us through this entire explainer. In Hindi, it's Ved अधिकार की परिभाषा कीजिए तथा उसके विभिन्न प्रकारों का वर्णन कीजिए. And in English, define legal right and explain its various kinds. This is our mission for today, to figure out what a legal right is and to explore all the different forms it can take.
So, before we can even start talking about the different types of rights, we first got to figure out what a legal right actually is. And, it turns out some of the most brilliant legal minds in history couldn't quite agree on one single definition. So what we're going to do is look at a few of their ideas to build a complete picture.
First up, we have Holland. Now, for him, a legal right is basically a power that the government, the state, gives to you. It's the ability to control what other people do, and here's the crucial part: the state will back you up. It's not just your personal wish. It's a power enforced by the entire legal system.
Then we've got Austin, who simplifies it even more. He says, look, a right is just one side of a coin, and the other side? A duty. You have a right only because the law forces someone else to either do something or not do something for you. Your right is basically the shadow cast by their legal duty.
But, and this is a big but, Austin's simple idea runs into a pretty serious problem. Just think about this dark example. A jailer has a legal duty to execute a prisoner. Now, if Austin is right and every duty has a corresponding right, well, does that mean the prisoner has a right to be hanged? Of course not. It sounds completely absurd, and it shows that the link between rights and duties isn't always so straightforward.
So if it's not just about duty, what's missing? Well, Iron comes in with a different angle. He says, let's talk about interests. We all have interests, an interest in our property, our safety, our reputation. Iron believed that the whole purpose of law is to choose which of these competing interests is going to protect. A legal right, then, is simply an interest that the law has decided to shield. But even that's not the full picture. Think about animals. The law protects animals from cruelty, right? That's an interest being protected. But does a dog have a legal right in the same way a person does? Can it go to court? No. So just protecting an interest isn't enough. There's one more ingredient needed. The law must also officially recognize who holds that right.
And that brings us to Salmond, who kind of puts it all together and gives us the definition that's most widely accepted today. He says a legal right is an interest that is both recognized and protected by the law. It's the whole package. The law sees your interest, it defends your interest, and it puts a duty on everyone else to respect that interest.
Okay, perfect. We've got our working definition. Now let's get into the really interesting part, exploring all the different flavors that legal rights come in. The law has a whole toolbox of different kinds of rights for all sorts of different situations.
First up, we have perfect versus imperfect rights. A perfect right is exactly what it sounds like. It's recognized by law, and you can enforce it in court. If someone owes you money under a contract, you can sue them. Simple. But an imperfect right is a strange one. The law recognizes it, but won't help you enforce it. The classic example is a debt that's time-barred. You waited too long to sue. The debt still technically exists, but you've lost the power to use the courts to collect it.
Next, positive versus negative rights. This one's pretty straightforward. A positive right means someone has a duty to do something for you. If someone damages your property, you have a right to get compensation, which means they have a positive duty to pay you. A negative right is the opposite. It means everyone else has a duty to not do something. Your right to own your home is a negative right. It imposes a duty on everyone else to not trespass and not interfere with it.
All right, don't let the fancy Latin scare you here. You'll hear in rem and in personam all the time. A right in rem is a right you hold against the entire world. Your ownership of your property is a right in rem. Every single person on the planet has a duty to respect it. A right in personam, on the other hand, is personal. It's a right you have against one specific person or group. If you lend money to a friend, your right to get that money back is a right in personam. It's against your friend, not the whole world.
Now let's look at proprietary versus personal rights. Proprietary rights are all about your property, your assets, things of the monetary value, your house, your car, your stocks. These are all proprietary rights. You can buy them, sell them, transfer them. Personal rights are about you as a person, your status, your well-being.
Think of your right to a good reputation or your right to personal liberty. You can't sell your reputation, right? It's tied to you and only you, and it ends when you do. Okay, another Latin pair, but trust me, it's easy once you break it down. Propria just means one's own. So a right in re propria is your right over your own property. You have complete ownership. Alina means another's. So a right in re alina is a right you have over someone else's property. A great example is a mortgage. The bank has a right, an interest in your property until the loan is paid off. It's often called an encumbrance.
This one flows nicely from the last one. Principal versus accessory rights. Think of it like a movie. The principal right is the main character. It can exist on its own. The accessory right is the sidekick. It's only there to support the main character. So in a loan, the debt itself, the right to get paid back, is the principal right. The mortgage or security for that debt, that's the accessory right. It's completely dependent on the principal right. If the debt is paid, the accessory right vanishes.
Now for a little trip back in time. This distinction comes from the Old English legal system, which actually had two different types of courts. You had the courts of common law, which were very strict, formal, and by the book. They created what we call legal rights. But sometimes following the strict rules led to unfair outcomes. So you could go to the courts of chancery or equity, which were all about fairness. And they created equitable rights to do what was just. Today, the courts are merged, but this distinction between the two types of rights still exists.
Let's talk about primary versus sanctioning rights. A primary right is a fundamental right you have all the time just by existing. Your right to personal freedom, for example. A sanctioning right is like an emergency right. It only pops into existence when a primary right has been violated. So if someone unlawfully detains you, they've violated your primary right to freedom, and in that very instant, a new sanctioning right is born, your right to sue them for damages.
Now, public versus private rights. A public right is held by the state on behalf of everyone. The right to a peaceful and orderly society is a public right. When someone commits a crime, they're violating that right, which is why criminal cases are always the state versus the individual. A private right is held by an individual. If someone breaks a contract they have with you, that's a private matter, a civil wrong between the two of you, not a crime against society as a whole.
And finally, vested versus contingent rights. A vested right is solid. You have it right now. No ifs, ands, or buts. All the conditions have been met. You own your phone. That's a vested right. A contingent right is a maybe right. It's an incomplete right that only becomes real if a certain event happens in the future. For instance, a will might say you inherit a house, but only if you reach the age of 25. Until you blow out those 25 candles, your right is purely contingent.
So after going through all those different types of rights, a huge question comes up. What about duties? Are rights and duties always linked? For every single right, is there always a corresponding duty? And does every duty have a corresponding right? Let's dig into this debate.
The traditional view, which Patton states perfectly here, is yes, absolutely. He says they are like father and son. You just can't have one without the other. If I have a right to something, someone else must have a duty related to it. It seems perfectly logical, right?
Well, you knew there was a but coming. Our old friend Austin is back, and he disagrees. He argued that while most duties are relative, meaning they relate to someone's right, there are also some absolute duties. These are duties that exist on their own, without any specific person holding the corresponding right.
And Austin actually laid out 4 types of these absolute duties. First, duties to yourself, like the duty not to harm yourself. Who holds the right there? Second, duties to the public in general, like not creating a public nuisance. You can't point to one person who holds the corresponding right. Third, duties to non-humans, like animals. And finally, your duty to the state or sovereign. In all these cases, Austin says there's a duty but no matching right.
Okay, for our final part, we're going to zoom in and get super precise. The word right is often used as a catch-all term for any kind of legal advantage, but a brilliant jurist named Hohfeld broke it down into 4 distinct building blocks. Understanding a system is like getting a secret decoder ring for complex legal problems.
Now, this table might look a little intimidating at first, but it's actually incredibly logical. Here's how to read it. The words in the same column are correlatives. They are 2 sides of the same coin and always exist together. If I have a claim, you must have a duty. The words in the same row connected by the diagonal arrow are opposites. You can't have both at the same time. You can't have a liberty to do something and also have a duty not to do it. Let's walk through each pair.
Let's start with liberty. A liberty is simply your freedom from the law to do something. You have the liberty to walk down a public sidewalk. What's the correlative of that?
It means everyone else has a no right to interfere with you walking down that sidewalk. Your liberty and their no right are perfectly matched.
Next is power. This isn't about physical strength, it's the legal ability to change legal relationships. When you write a will, you are exercising a power to change who owns your property after you're gone. The correlative of your power is someone else's liability. This means they are subject to having their legal situation changed by your exercise of power. Your power is their liability.
And finally, we have immunity. And immunity is like a legal shield. It means you are not subject to someone else's legal power. A foreign diplomat, for example, has immunity from being sued in local courts. What's the correlative of that? Well, it means that ordinary citizens have a disability. They lack the legal power to sue that diplomat. The diplomat's immunity is your disability. They are two sides of the same coin.
And there you have it, a deep dive into the incredibly complex world of legal rights and duties. We went from the basic definitions all the way through 10 different kinds of rights and even into Hohfeld's advanced framework. I really hope this detailed breakdown was helpful for your studies. If you found it useful, please hit that like button and be sure to subscribe to the channel for more legal explainers just like this one.